Section 52 of Transfer of Property Act, 1882, Doctrine of Lis Pendens. Section 52. Transfer of property pending suit relating thereto. During the pendency, in any court having authority, within the limits of India excluding the state of Jammu and Kashmir, or established beyond in pro limits, by the central governor, which any right to a movable property is directly and specifically in question. The property cannot be transferred or otherwise dealt with by any party to the suit or proceeding, so the rights of the affect the rights therein, except under the authority of the court and on such terms as it may impose, or the institution of the proceeding in a court of competent jurisdiction, and to continue until the suit or proceeding has been disposed of by a final decree or order and complete satisfaction or discharge of such decree or order has been obtained, or has become unobtainable by reason of the expiration of any period of limitation prescribed for the execution thereof by any law for the time being in force. Essentials of Doctrine of Lis Pendens. The basis of the doctrine is necessity, so it is immaterial as to whether the transferee had any notice of suit pending in the court or not. The transferee is bound by the order of the court even if he had no actual or constructive notice of the pending suit. The pendency of the suit starts from the date on which the plaint is filed in the court and ends on the date on which the final decree is passed by the court, as mentioned in the explanation to Section 52. Following are the essentials of Doctrine of Lis Pendens as described in Section 52. There must be a pendency of a suit or proceeding. The suit proceeding must be pending in a court which has the jurisdiction to try it.
A right to a movable property is either directly or indirectly involved in the suit or proceeding. The immovable property in dispute is transferred or dealt with by any party to the suit. Such transfer or dealing affects the rights of the other party involved in the suit or proceeding. Transfers of property may either be done by the act of the parties or by operation of law. Transfers by operation of law are called involuntary transfers. Earlier, there was some dispute about the applicability of the doctrine of Lis Pendens to involuntary transfers. The matter was settled by the Privy Council in the case of Neelkant vs Suresh Chandar, and now the doctrine is applicable to both kinds of transfers. Further, the Supreme Court, in Samarendra Nath Sinha vs Krishna Kumar Nag, stated that although Section 52 does not strictly apply to involuntary alienations, for example court sales, but it is well established that the doctrine of Lis Pendens applies to such transfers. Once all the conditions are fulfilled, the transferee is bound by the court's decision. If the decision of the court is in favor of the person transferring the property in dispute, transferor, the person to whom the property is transferred, transferee, gets all the rights attached to that transfer. If the decision is against the transferor, the transferee does not get any right because the transferor has no right to transfer the property anymore. Although, it must be noted that Section 50 does not invalidate any transfer but makes it subject to the rights of the parties involved in the suit. In Gauri Dutt Maharaj vs Sheikh Sukur Muhammad and others, it was observed that the principle underlying Section 52 is to maintain the status quo. The doctrine of Lis Pendens is not applicable where the suit is collusively instituted with mala fide intention. This means that there is no actual dispute but the suit is filed for some evil motive, for example defrauding a third party. Doctrine of Lis Pendens. The doctrine of Lis Pendens is incorporated in the Transfer of Property Act, 1882, under Section 52. Lis means litigation and pendens means pending, literally signifying pending litigation. Any action or proceeding which is pending in any court of law is said to be Lis Pendens. The maxim representing this doctrine accurately is pendent lit nihil innovatur, which means that, during the pendency of litigation, nothing new should be introduced. The principle behind this doctrine is that nothing new should be introduced into a litigation that is pending, that is to maintain the status quo, to abstain from doing anything which may affect any party to the litigation. In terms of property law, it implies that no new interest in respect of a property should be introduced, if that property is the subject matter of a litigation. If a new interest or title is created in that property, that would amount to a transfer of that property. The doctrine of Lis Pendens prohibits the transfer of any property under litigation. Origin of Doctrine of Lis Pendens. The doctrine of Lis Pendens has its origin in the case of Bellamy vs Sabina, wherein Justice Turner observed that the doctrine of Lis Pendens was a doctrine common to the courts of law as well as equity, since it would become almost impossible for the suit that is instituted in a court to be adjudicate if alienation pendent light were allowed to prevail. The plaintiff, in such a situation, would be liable to be defeated by the defendants causing the alienation before the judgment is passed, every time, and would be driven to institute a new course of proceedings. Every time. The doctrine of Lis Pendens is a very old doctrine of common law. Since speedy and effective remedies are the requisites of a judicial system, it is important to ensure that there is no invasion of any right or title of any party interested in the property. The litigation process should not be defeated because of private transactions, otherwise the purpose of seeking relief from the court would be rendered useless and ineffective. The doctrine of Lis Pendens is based on necessity as it prevents the parties from disposing of property that is in dispute, to not interfere with the court's proceedings. The decision of the court is one to be honored and all the parties interested in the action will be bound by it. If there were no rule to prohibit alienation of property during pendency of the suit, all successive transactions would be rendered ineffective and no person would be able to settle his rights in the property. Doctrine of Lis Pendens in India. In India, the statutory provision for the doctrine of Lis Pendens is mentioned in the Transfer of Property Act. Section 52 states that if any suit or proceeding is pending in any court having authority within India, or in any court established by the central government outside India, any immovable property that is part of that suit or proceeding cannot be transferred or otherwise dealt with by any party to the suit, in such a way that such transfer or dealing would affect the rights of any other party to the suit or proceeding. Such a transfer or dealing can only be effected if the court allows it, and it may impose certain conditions as it may deem necessary. Moreover, the suit or proceeding that is instituted should not be collusive in nature and must involve a right to the immovable property that is in question. The explanation to this section provides the pendency of proceeding would begin on the date the plant is presented as well as instituted in court of competent jurisdiction, and it would end on the date the final decree or order is passed by the court, or if it has become unobtainable because of expiry of the limitation period. As per Section 52, the effect of doctrine of Lis Pendens is not to invalidate the transfer but to make it subject to litigation. According to the view taken by the Indian courts, it has been held that the foundation for the doctrine of Lis Pendens does not rest upon notice, actual or constructive, it rests solely upon necessity, the necessity that neither party to the litigation should alienate the property in dispute so as to affect his opponents. In Rajendra Singh vs. Santa Singh, the Supreme Court observed that the doctrine of Lis Pendens intends to strike at any attempts made by the parties to the suit to curtail the jurisdiction of the court through private dealings, which affect the subject matter of the suit and prevent the court from deciding a dispute in relation to that property and hence, frustrate the decree. Where the doctrine of Lis Pendens is not applicable. 1. Where there is a private sale by a creditor holding the right to dispose of the mortgaged property even if there is a suit for redemption filed for the same. 2. If the property is not described clearly, or if it cannot be identified, the doctrine of Lis Pendens will not be applicable. Mere mention of the property is not enough, it should be identifiable. 3. Where there is a suit for maintenance only for the maintenance payments to be ascertained transparently, the doctrine of Lis Pendens will not apply because the property is not directly in question. 4. Where a court orders restoration of an immovable property under Order 21, Rule 63 of the Civil Procedure Code, 1908, the doctrine of Lis Pendens is not applicable. 5. Where a transfer is effected by a person who is not a party to the suit. 6. Where the transferor is only partly affected because of the transfer.
Conclusion. A purchaser pending light is given an opportunity to defend himself. If the interest of such purchaser is substantial, he can be made as a proper party to the suit. But his rights or title would be subject to the decision of the court, and any condition that it may impose. The purchaser is entitled to be pleaded in the suit or any other proceeding where his predecessor was party to the litigation. The doctrine of Lis Pendens is in consonance with public policy, and with the principles of justice, equity and good conscience. The provision under Section 52 bars any party to the suit to take decisions of alienation of property themselves and interrupt the working of the court. It further ensures that no person's right is curbed due to another's will. Please subscribe and share if you like the video. Thank you.